Full information as to the machinery and procedure of the office and the requirements necessary to obtain the services of the public trustee are obtainable on application to the public trustee office, Clements Inn, London. Scotland. The history of the law differs considerably from that of England, though perhaps the position of the Scottish trustee is now not very different from that of the trustee in England. The Statute of Uses did not apply to Scotland, since neither that nor any similar legislation was necessary in a system in which law and equity were administered by the same tribunals. Trustees seem to have existed from time immemorial and have been frequently regulated by statute. The policy of the English Statute of Frauds was no doubt intentionally imitated in the Act 1696 C25, enacting that no action of declarator of trust should be sustained as to any deed of trust made for thereafter, except upon a declaration or backed bond of trust lawfully subscribed by the person alleged to be trustee and against whom or his heirs or assignees the declarator should be intended, or unless the same were referred to the oath of the party simpliciter. The Act does not apply to all cases, but only to those in which the act of the parties, sorry, but only to those in which by the act of parties documents of title are in the name of a trustee, but the beneficial interest in another. The person creating the trust is called a truster, a term unknown in England. On the other hand, the term Seteki trust is unknown in Scotland. The office of trustee is prima facie gratuitous as in England, it being considered to fall under the contract of mandate. Some of the main differences between English and Scottish law are these. There is no presumption in Scotland of a resultant trust in favour of a purchaser. A trust which lapses by the failure of a beneficiary goes to the Crown as ultimus heiress. The office of trustee is not a joint office. Therefore, there is no right of survivorship, and on the death of a trustee, the survivors are incompetent to act unless a certain number be declared or presumed to be a quorum, or the office be conferred on trustees and the acceders and survivors of them. Sometimes the concurrence of one trustee is rendered absolutely necessary by his being named sine qua non. The Court of Session may appoint new trustees, but generally appoint a judicial factor. There has been a considerable amount of legislation, chiefly in the direction of extending the powers of trustees and of the court in trust matters. The powers of investment given to trustees are much the same as those allowed in England. United States. In New York and many other states, uses and trusts have been abolished with certain exceptions, and every estate subject to those exceptions is deemed a legal right cognizable in courts of law. Some of these exceptions are implied trusts and express trusts, to sell land for the benefit of creditors, to sell mortgage or lease lands for the benefit of legatees, or for the purpose of satisfying any charge thereon, to receive the rents and profits of lands and apply them to the use of any person during the life of such person or any shorter term, or to receive such rents and profits and accumulate the same within the limits allowed by the law. Some states allow the creation of trusts other than those arising by implication or operation of law, only by means of will or deed. Where the trust is of real estate, the deed must generally be registered. Forms of deeds of trust are given to the statutes of are given in the statutes of Virginia and other states. The English doctrine of Cyprus is being adopted in many states. A public trustee as a corporation sole exists in some states. A trustee under American law is generally entitled to compensation for his services. Spendthrift trusts, that is, those under which the enjoyment of income bequeathed by will in such a way as to prevent creditors of the beneficiary from reaching it before it gets into his hands, are generally supported. Nicholas versus E.O.N., 91 United States Reports 713. A voting trust is a concerted transfer of their shares in a corporation by a majority of the shareholders to trustees to hold and vote on them for a specified period for the purpose of securing the adoption or continuance of a certain line of corporate action. Any shareholder may recede from such an arrangement and reclaim his stock. All right. And the authorities, the principal authority is Lewin's Law of Trusts. Other treaties are those of Godfrey and Underhill. For American law, see Perry on trusts. The principal authority on charitable trusts is Tudor. For the history, may be consulted Bacon, law, law tracts, reading on the statute of uses, Gilbert on uses, Sanders on uses and trusts, Spence, equitable jurisdiction, Digby, history of the law of real property. All right. So we came across some words. So we're gonna check those words. Sign, Quanon. All right, let's go from the top. Let's go from the top. So we started rights and duties of the trustee. Right. So we started here. We came across some words. Um, uh, so sign Quanon is one. We're gonna check out that. We're gonna check out truster. We're gonna check out simpliciter. And all right. So we're gonna check out simpliciter, sign Quanon, truster. All right. Ultimus eris. All right. So simpliciter. We're gonna go to the Black's Law Dictionary. This is the 8th edition. Simpliciter. Simpliciter is the Latin adverb in a simple or summary manner. Simply, absolutely, unconditionally. Simpliciter. Right? Simpliciter. Absolute or unconditionally. So oath of party, simpliciter, absolute unconditionally. All right, we're gonna look for truster, truster. Well, I guess we know what truster is. Is the one who creates our trust in Scotland. So, but we're still gonna look up the definition. Truster. Trust, trustor, trustor, one who creates a trust, trust legacy, trust endorsement, trust fund, trust, trust E. Mhm. All right. So I'm not finding truster in this. Let's try the um Webster's truster. 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 Oops. Jump a bit too far there. Try trust. 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 Trusted. Trustee. Truster. So truster in the Webster's 1898, one who trusts or gives credit. Truster, no. All right, one who trusts or gives credit. All right. So the truster is one who trusts. So the person creating trust, you have to trust somebody to create a trust. So the truster. All right. We know what Seteki trust mean. We know that means beneficiary. All right. Let's see. Ultimus eris. Ultimus eris. Ultimus eris. Ultimus. Ultimus eris. All right. So see heirs. Ultimus eris. See heirs. So we're gonna go to H. All right. All right. Heiress. Ultimus heiress. The last or remote heir. The Lord. So Ultimus heiress is the last or remote heir, the Lord. So a trust which lapses by the failure of a beneficiary goes to the crown as Ultimus heiress. The last or remote heir, the Lord. All right, sign. Then we're gonna look at sign qua non. Sign qua non. Sign qua non. Sine qua non. See what sine qua non means? Sine qua non. Sine. Right. Sine qua non. Latin. Without which not. Without which not. An indispensable condition or thing. Something on which something else necessarily depends. Without which not. So if something doesn't happen, something else couldn't happen. Without which not. An indispensable condition or thing. Something on which something else necessarily depends. Also termed conditio sine qua non. Right? So without which not, sine qua non. Sine qua non. Without which not. Sometimes the concurrence of one trustee is rendered absolutely necessary by his being named sine qua non. So without which not. So sometimes a concurrence of one trustee is rendered absolutely necessary by his being named sine qua non. So it means that without this trustee needs to do something or whatever is to happen depends on this trustee for it to happen. Sine qua non, without which not. So without this trustee, um, something wouldn't happen. All right. So sine qua non. Right. Yeah. So that's the Latin terms that we came across in this. Nice guys. Thank you for your time. We're gonna continue on trust. So this was trust and trustees. This was trust and trustees that we read from. Right. Trust and trustees. Now we've reached trusts, and we're gonna take it from trusts going forward from the next read. All right, so thank you for your time. Remember, strengthen body, powers, and mind. Keep reading, keep studying, keep learning, keep growing. And we on the right path. All right, guys? So stay up.